Mr. Paul?
It's just an infraction, Your Honor.
Infraction, okay. Yeah, infraction, Judge. All right, very well. And Mr. Grayson, is that correct?
Yes, sir.
There are a number of questions that I do need to ask you in order to ascertain whether you are knowingly and voluntarily entering your plea. Sir, how old are you?
Sir, I'm 29.
Are you married or single?
I'm single.
Are you employed?
Yes, I'm employed.
What type of work do you do?
I work at Scary Aircraft.
What is the highest education level you have obtained?
Maybe about 1 year of college. I got my diploma.
Are you making your plea voluntarily?
Yes.
Have there been any promises or threats made to you which have influenced you to plead no contest?
No, there is not.
I understand there have been certain plea negotiations entered into between your counsel and counsel for the state. You understand even though the attorneys may make certain recommendations in regards to sentence, the decision in regards to appropriate sentence is mine pursuant to the sentencing guidelines for the state of Kansas. Do you understand that?
Yes, I do, Your Honor.
When you plead no contest, you surrender and waive certain legal rights you'd otherwise have if you chose to go to trial. You understand you have the right to a speedy trial where your guilt or innocence would be determined by a jury, or if you chose to waive a jury, by a judge.
Yes.
You understand at such a trial you would have the right to confront the witnesses against you and have them cross-examined by your attorney.
Yes, sir. I understand.
You understand at such a trial you would have the right to subpoena witnesses who may have information favorable to you and call them to testify on your behalf.
Yes, I understand.
You understand at such a trial it would be the burden of the state to prove your guilt beyond a reasonable doubt on each element of the charges against you before you could be found guilty.
Yes, I understand.
You understand the judge and the jury must presume you are innocent until the state proves otherwise, if ever beyond a reasonable doubt.
Yes, I understand.
You understand if convicted at such a trial, you'd have the right to ask the court for a new trial, and if denied, you'd have the right to appeal your conviction and your sentence to the appellate courts of the state of Kansas.
Yes, I understand.
You understand you're giving up each one of these rights if you plead no contest.
Yes, I understand.
You understand the sentence which may be imposed.
Yes, I do understand, Your Honor.
This is a severely level 5 drug felony. In regards to the count 1, unlawful possession of marijuana, third conviction, you could be sentenced anywhere from 10 to 42 months in prison. You would have a criminal history of 3 or more non-person felonies or less. There is a presumption you would be placed on probation. If you would have a criminal history of 1 person or 1 non-person felony, or 1 person felony, you fall within a border box whereby it would be at the discretion of the court whether you're placed on probation or in prison. If you would have a criminal history of 2 person felonies or more, there's a presumption you would be placed in prison. As you appear before the court today, I do not know what your criminal history is, if any. You would best know what your criminal history would be. Do you have any question as to the sentence the court may impose? Driving on a lane roadway is an infraction subject to a fine. You understand that in addition to the possible sentence and fine, the court will order payment of court costs. They may require to pay restitution for any personal injury or property loss. They may impose administrative costs of a probation program and may require you to reimburse the state for your indigent legal fees. Do you understand that in addition to the possible sentence and fine, the court will order payment of court costs and may require to pay restitution for any personal injury or property loss, and may impose administrative costs of a probation program, and the court may require you to reimburse the state for your indigent legal fees.
I do understand that.
Have you ever been adjudged mentally ill by a court?
No, I have not.
Ever had a guardianship or conservatorship set up to handle your affairs?
No, I have not.
Are you presently under the influence of any intoxicating liquors or drugs?
No, I have not.
Have you had plenty of time to discuss this case with your attorney?
Yes, I have, Your Honor.
Would you like any more time to talk to Mr. Paul about the matters we've just discussed?
No, thank you.
Keeping in mind all matters we have discussed, is it still your wish to plead no contest?
Yes.
Court at this time will accept a factual basis from the state.
On or about the 20th of January,
Grayson, do you know of any reason why the court should not accept your plea?
No, I'm not.
Mr. Paul?
No, Your Honor, we ask that you accept it.
Mr. Grayson, the court finds you are alert and intelligent, that you understand the nature of the charges and appreciate the consequences of pleading no contest. I further find you understand the rights you're giving up by pleading no contest. I do find the facts of the case to be sufficient to find you guilty of unlawful possession of marijuana, third conviction, and driving on a lane roadway, an infraction. I further find your decision to plead no contest is freely given, and that you have had the advice of a good attorney with whom you are well satisfied. Therefore, I do accept your plea of no contest. Court at this time will schedule sentencing, and I believe the next appropriate sentencing date would be March 6th. March 6th at Crestwood, 9 o'clock.
9 a.m. would be perfect, and it will be by Zoom.
Perfect. Okay, March 6, 2025, 9 a.m. by Zoom. March 6, 2025, 9 a.m. by Zoom. Immediately after this hearing, Mr. Grayson, I do order you to contact Telephone Court Services for a pre-sentence investigation report interview. Their phone number is 316-322-4153. 316-322-4153. Subsequently, the court does retain you on the bond you have previously posted. I do order you to stay in contact and communication with Mr. Paul and your bail bondsman. Keep them both advised all times, current address, telephone number, place of employment. Court does note that case number 23TR126 is ordered dismissed. All other counts in 24CR21 are ordered as dismissed. Anything further to come before the court? Miss Shirley?
No, thank you, Your Honor.
And Mr. Paul?
No, thank you.
Your Honor. Further to come before the court, Cardinal?
Your Honor,
Yes.
if Mr. Cortez can call our office tomorrow instead of today, there is nobody in that office today.
Okay, the court orders you to call the office tomorrow, Mr. Grayson. Mr. Grayson, call tomorrow at office number for scheduling a pre-sentence investigation report interview.
Sounds good.
There being nothing further to come before the court, court is in recess. Mr. Grayson, you're free to go, and have a good day.
Thank you. Now, Judge, after you call Mr. Reagan's Clark's case, I have an announcement, okay?
Okay.
Thank you.
Court goes on the Zoom record. Cases entitled State of Kansas versus Terry Reagan's Clark, 23 CR 56. State of Kansas appears by Assistant Fremont County Attorney Marianne Shirley. The defendant, Mr. Terry Reagan's Clark, appears in person and by court-appointed counsel Richard Paul. And announcements to the court, Mr. Paul.
Yes, Judge, I just received the PSI on that. I haven't really had a chance to go over it. We'll really get a copy to Mr. Reagan's Clark. I spoke with Ms. Gillette about this, and she was not going to have an opposition to any continuance, Judge.
That's correct, Your Honor.
Thank you, Ms. Shirley. Thank you, Mr. Paul. Court grants the motion for continuance.
You want to set that on the February 13th at 2, Judge?
Yes, February 13, 2025 at 2 p.m. by Zoom. And that will be, that we will take up at that time motions and also sentencing for Terry Reagan's Clark. Thank you, Your Honor.
Nothing further.
And Ms. Shirley.
Okay, thank you.
Judge, I believe that's it, and I'm excused.
Yes, there being nothing further to come before the court, court is in recess. And Mr. Terry Reagan's Clark, you're also free to go.
Your Honor, I have Mr. President today. I would request to break out with Ms. Shirley if that is acceptable.
Yes, and Ms. Gutierrez to have a breakout room with Ms. Shirley.
Okay.
Your Honor? Yes. Is there any way I could go to that breakout room too, just so I'm present? Sir, your name? Anthony Beal or Antonio Perez Beal. We'll make inquiry with your attorney once she comes back out of that breakout room. But at this point in time, I've only authorized the two to go into the breakout room. Once your attorney comes back, I'll then have her be advised that you wish to meet with her also. Yes, sir. Thank you. Yes.
Your Honor, this is Jessica Gutierrez. We are out of the breakout room and we are ready to form the record if you are. Judge, we have everyone back in the breakout room.
And Ms. Gutierrez, when you were in the breakout room with Ms. Shirley, I believe it was your client, Antonio Perez Beal, that expressed wish to talk with you.
Okay.
So, you wish to talk with him?
Yeah, if there's a way to do that privately in the breakout room, that would be fine, Your Honor.
Okay. Chris, I'm going to check with you to see if you can put them into a breakout room.
Yes, this is Mark Schonifer. We are prepared to proceed on our case whenever the court is ready to take us up. We know that Mr. Ernest is here on behalf of Mr. Kearns, and he too is prepared. So whenever the court is ready, we're ready as well, Your Honor. Thank you.
Okay, Marianne? As soon as we get a county attorney work, we'll take up the case.
Yes, Your Honor.
Okay, hi, Marianne. Okay, we'll take up,
My client is Joshua Anderson, Your Honor.
thank you.
And Judge, after Mr. Schonifer and Mr. Ernest, we also have Mr. Ambrose.
Okay, thank you, Chris. Okay, for the record, court understands that Mr. Anderson is on docket in regards to a warrant to show cause matter. And the court at this time will go on the Zoom record. Case is entitled State of Kansas versus Joshua Anderson. Case number is 22 CR 66. State of Kansas appears by Assistant Greenwood County Attorney Marianne Shirley. The defendant, Mr. Anderson, appears in person and by his attorney, Mark Schonefer. This matter does regularly come back before the court this day on a work to show cause as to why the defendant should not be revoked from his probation. And announcements to the court at this point in time, Mr. Schonefer.
Your Honor, we're prepared to go forward today on this warrant. My client is not requesting an evidentiary hearing on it. He will stipulate to being in violation of probation and would like to make arguments as to disposition after that, Your Honor.
Thank you, Mr. Schonefer. And Mr. Anderson, Mr. Schonefer has advised the court you do wish to admit to being in violation of the terms and conditions of your probation. Is that correct?
Yes, Your Honor.
You understand by making this admission, the court could very well revoke your probation and order you to serve the balance of your sentence previously imposed.
Yes, Your Honor.
Have you had adequate and sufficient opportunity to consult with Mr. Schonefer prior to making your admission here today?
Yes, Your Honor.
Mr. Anderson, the court does find that you are knowingly and voluntarily admitting to the probation violation, and the court does accept the same. Subsequently, the court will accept argumented recommendations as to disposition, beginning first with the state and Ms. Shirley.
Thank you, Your Honor. It's my understanding, based on the record, that this in fact was a matter which was a water box initially. He has continuously violated the use of drugs. He still has a balance of $958 in the preceding, I believe, several months. It's been 5 months since everything was supposed to come before we could get a court date. He's made no attempt to make any payments. At this point, it does not appear that he has had any sanctions. However, because it was a border box, the court's not necessarily, doesn't necessarily have to do that. In the event that the court chooses not to impose the sentence, we would ask that after a sanction of 30 days, that he in fact be placed on community corrections, because clearly regular court services was not sufficient to meet his needs.
Thank you, Ms. Shirley. Now, recommendations from the defense, Mr. Schonefer.
Thank you, Your Honor. Unfortunately, I don't think Ms. Shirley was given an update by the court services officer that's been supervising my client. My client has been reporting every month. He's paid all but $47 of the fines. If given a drug evaluation today, he would draw whatever the court would want. He would be clean. He's working at Q's Carryout. He's also applied for a second job at a furniture warehouse here in Wichita. He's also enrolled in WTI for the spring semester. He just released 2 weeks ago from the hospital, but he's doing everything he can to comply with the state. He has a 2-month-old child, Your Honor. I'm asking because there's been no previous PVs, and that he's on court services right now. Pursuant to KSA 223716, small c1, uppercase c, that because he has not committed a crime, has not absconded from supervision, and the court cannot find that the safety of the members of the public will be jeopardized or the welfare of the inmate will not be served, that he be placed on community corrections, which is what the law requires. Because he has not had a previous probation violation, the law requires that since he's never been sent to community corrections. Asking that the court place him on community corrections. I think he's made a lot of efforts, Judge. None of the, in the addendum to pending warrant to show cause, they mentioned some contact with police officers. He's not been charged in any of those incidents. In fact, none of those can be attributed to him. He was in a bad place, but at the same time, he has not been charged with any of those crimes. So what this amounts to, Judge, is that he did not report in a timely fashion, that he had contact with a police officer, and secondly, that he was hot for marijuana. And while it's no excuse that he was hot for marijuana, Judge, we are surrounded by 3 states where marijuana is legal, and there's been an influx of people using that drug. Not an excuse, not making an excuse, but what I'm trying to point out is simply this, that he should not have had marijuana, shouldn't be drinking, but he's not messing with methamphetamines, he's not messing with fentanyl, he's not out there committing new crimes. He's on probation, Judge. I'm asking the court consider, because of the efforts that he's been making, that he be placed in community corrections and just continue on probation. So those are my recommendations, Judge. If the court has other questions, I'd like to be able to answer those for you before we make a decision.
Thank you, Mr. Schonefer. The court has had an opportunity to review the file, listen to the arguments from respective counsel. Subsequently, the court does revoke Mr. Anderson from his court services probation, places Mr. Anderson on community corrections probation subsequent hereto. And the court would order that Mr. Anderson, you contact community corrections today in regards to that program. Court orders you to contact community corrections today. Subsequently, all other terms and conditions of sentence remain in force and effect.
Thank you,
Your
Congressman.
Honor, what term is the probation for?
Recommendations from counsel, Ms. Shirley,
12 months should be sufficient.
Mr. Schaffner.
Your Honor, that sounds reasonable to me.
That is the order of the court, 12-month community corrections, beginning today.
Thank you, Your Honor.
Good luck to you, Mr. Anderson. There being nothing further to come before the court, court is in recess. Have a good day, and you're free to go.
Your Honor,
Yes.
I was here to appear with Mr. Anderson. I'm the supervising officer of Central County for Mr. Anderson. Am I free to go?
Yes, you are.
Thank you, sir. You have a good day.
Thank you for your appearance.
Your Honor, I think we're ready to take up Mr. Craig's cases. We are going to be asking for continuance.
Okay. All right. We'll go on the Zoom record. Cases entitled State of Kansas versus Antonio Manuel Perez Beal. There's numerous and sundry cases, I believe. 24 CR 56, 24 CR 57, 24 CR 96, 24 CR 128, 24 CR 141, 23 CR 157, Gulf County 23 CR 30001. The state of Kansas appears by Assistant Greenwood County Attorney Mary Ann Shirley, and the defendant appears in person and by his attorney, Jesse Gutierrez. And announcements to the court, Ms. Gutierrez.
Yes, Your Honor, just one correction to that case announcement. I do not believe we are here on the Elk County case. I believe that's set for Monday with Judge Lee.
First stands corrected, set for Monday with Judge Lee. Thank you.
Thank you, Judge. Your Honor, we are asking for a continuance of these matters that are set for sentencing. We just received the PSI reports a few days ago. There was something in there that we're not anticipating that we just need time to likely prepare a motion for departure. I don't anticipate that will be objected to by the state, but we just need about 30 days to prepare that and work those things out.
Thank you, Ms. Gutierrez. And Ms. Shirley?
That's my understanding, Your Honor. It was anticipated that Mr. Perez has little to no prior history. We anticipated that he would be a presumptive probation case, and that PSI, the court of law, has come back differently. So I believe that an appropriate motion for departure should be filed before the matter comes before the court.
Okay, and I just wanted to check, there's so many cases involved. I'm just showing two PSIs, one on 24 CR 57 and one on 24 CR 96. Am I missing any?
No, Your Honor. Those are the two felonies, and I would just like to note for the record that the only criminal history that was scored in these matters and that resulted in a presumptive prison are the cases, the convictions we're here on today. So, there are just two PSIs, Your Honor.
Thank you. All right, the court grants the motion for continuance, finding that defense may very well need to file appropriate motions prior to sentence. And Chris, I'm going to check with you on what would be appropriate day and time.
Judge, our February 13th date is getting pretty filled up. Is March 6th too long? We can squeeze it into the February 13th if we need to.
Well, I don't think I'm going to squeeze in this many
It's
cases.
several cases.
Yeah, let's move to the March 6th.
At 9 a.m., please.
March 6th, 2020, live at 9 a.m. by Zoom. March 6th, 2025, at 9 a.m. by Zoom. Does that work for the state?
Yes, Your Honor.
And does that work for the defense, Ms. Gutierrez?
Yes, Your Honor.
Okay, then that'll be the next date set for sentencing. In regards to Mr. Perez Beal, I advise continue Mr. Perez Beal on the bond previously posted. And I do order Mr. Perez Beal to stay in contact and communication with Ms. Gutierrez and his bail bondsman. If been both advised all times, current address, telephone number, place of employment. Anything further to come before the court, Ms. Shirley?
Nothing, thank you.
And Ms. Gutierrez?
Thank you.
There being nothing further to come before the court, court is in recess. Mr. Perez Beal, you're free to go. Have a good day, Ms. Gutierrez.
Thank you, Rafa.
Your Honor,
Yes, Tony.
that was the last one I was here covering this morning. Not excused.
Yes, have a good day, Tony.
Thank you.
Your Honor, I'm here for Kirk Carnes, and I was hoping we could address Mr. Cannon's matter.
Yes. Be just a moment. Be just a moment.
Okay,
I'll be with you in just a moment.
thank you.
All right. Case is entitled State of Kansas versus John Cannon. Case number 23CR20. State of Kansas appears by Assistant Elk County Attorney Marianne Shirley. The defendant, John Cannon, appears in person, and by his attorney, appearing on behalf of Kirk Carnes is, and can you say your name, please?
Patrick Ernest.
Appearing at this time is Patrick Ernest, and this would be representing John Cannon. And announcements to the court, Mr. Ernest.
Yes, Your Honor. Mr. Carnes ended up having to go to the doctor and is requesting 2 weeks to be able to determine whether or not Mr. Cannon is going to enter into a plea agreement that I believe has been previously offered. So if we could get a date 2 weeks out, I would very much appreciate it.
Thank you, Mr. Ernest. And Chris, do we have any time on the, I believe it's the 13th?
We do, Judge. Now that one we can squeeze in.
Okay. And then,
Let's do February 13th at 2.
okay. And the matter for Mr. Cannon is continued to February 13, 2025 at 2 p.m. by Zoom. February 13, 2025 at 2 p.m. by Zoom.
Your Honor, is that for a status? Or I'm not sure what the current setting is.
Well, I believe that would be at that point pretrial conference plea hearing. Pretrial conference plea hearing.
Okay, thank you.
Judge, in that case, could we maybe put that at 9?
Let me check with Mr. Ernest. Would 9 o'clock work on that? February 13th, then? It will be by Zoom.
If not, that's okay.
Let me check my calendar in case Mr. Carnes isn't available. At least maybe I could be. Let me make sure. It looks like at a minimum I can be available, so that may work.
Well, does Mr. Kearns need to be available in order for the case to be resolved?
Hopefully not, if he's already spoken to Mr. Cannon by that point. And this will be 9 a.m.
Thank you, Mr. Ernest. The court does schedule this instead of at 2 p.m. Court schedules this for Thursday, February 13, 2025 at 9 a.m. by Zoom. February 13, 2025, Thursday, 9 a.m. by Zoom. Otherwise, the court continues Mr. Cannon on the bond previously posted, ordering Mr. Cannon to stay in contact and communication with Mr. Kearns and Mr. Ernest and his bail bondsman, keeping them advised all times. Current address, telephone number, place of employment. Anything further from the state, Ms. Shirley?
Nothing at this time. Thank you, Your Honor.
Thank you, Your Honor.
Anything further, Mr. Ernest?
No, Your Honor.
There being nothing further to come before the court, court is in recess. And Mr. Cannon is free to go. Mr. Ernest, have a good day.
Thank you.
Josh, could you have Chris toss me and Jessica and Marianne in the breakout room real fast before we go?
Yes.
I can sure do that.
That'll be quick.
Take your time.
time I had trouble with it. Okay. Judge, our electricity is doing some strange things up here.
Is it really? Oh, Lord.
Like, Mr. Ambrose, do you need a breakout room with your client now?
Yeah, that'd be great. Probably just 30 seconds or so, so I can give her an update for it.
Officer, show us how to do it.
Normally I can do it like that when I have them downloaded to my computer, unless I pre-download like a million things on here, but
It's only 15 minutes. It's only 15 minutes. And,
the county gave me a computer with only a 500 gigabyte hard drive.
it comes on.
On March 24, 2023, clearly advised John Byron Fanning at 1342 10th Street, Severn, Kansas, your driving privileges have been reinstated.
But he failed that test and did not comply with the things that he needed to do between that letter being issued and the stop. He had not complied with all of those things, Judge. We would ask you to reconsider because he did not have it. And according to Burton, they can tow that car for any reason, which was a case out of this.
Status conference, November 13, 2023.
status conference?
The license in his possession and reinstated.
But he failed that test and did not clear because he did not have it. And is not charged with 8-262. He's charged with 8-235, which requires a valid license in his possession, which he did not have. This is not an 8-262 case. This is an 8-235 case, which says you have to have a valid license.
Court stands corrected. Court stands corrected. This is a stop as to Mr. Cannon not having the license in his possession. Subsequently, the court reconsiders.
Killjoy, you haven't provided the audio recording of this committee. The chairman requested that it was due Thursday. You didn't give us an advance copy of your opening statement, but yet the reporting on it somewhere else. There seems to be more information from YouTube videos than you're able to provide for us, and it begs the question to anyone, you're in charge of the investigation of your own failure, so how is anybody in America supposed to be able to trust the results of that investigation as being anything transparent and genuine? That's the last question, but please feel free to answer the question.
Just dicks. Caw. Titsy. Sure shit.
He finally passed the driving test April 21st, 2023. An SR-22 was mailed April 13th, 2023, and it was recorded April 30th, 2023. You finally met all your requirements on May 1st of 2023.
Officer. You just think that's not. You're the one that please.
I really actually expected after.
You have to talk to me after. Right up my ass.
Well, when we first turned, I seen your vehicle. No, let me finish, JB. No, when we first turned, I was trying to check and see your rear views to see if Cody or someone else was driving. I had really expected you to not be driving after we had that conversation.
Well, you know what? Even Shirley said, well, if that's all you can do, that's all you can do. And I said, yeah, that's all I can do. She said, well, if you're again, just come get me. Just call me, I'll come get you. Did a whole job of explaining, but that was the advice of a lawyer. Mary Ann Shirley is a lawyer, and he said Shirley said, so.
Wait, go ahead, put this in first aid. Let's go. Call Cooper. Who was it, Steve? Yeah, call Steve. I'll give you that.
You're trying to get a couch.
Wait, back in the truck. We're not leaving. Just go hand it to me. I'm not leaving until I get it back up because I have to drive your vehicle again. Hand it to me. I'll keep it in my hand. I'll put it in front of me.
because if you had a valid driver's license, you wouldn't need the paper. And if only there was part of the vehicle.
Yeah, it was a valid driver's license and an ID only.
We're going to go with the ID that expired February 2029 that was the ID.
It comes back as ID only. It's not about the restrictions, it's not about the thing. You do not have a valid driver's license. They explain it. No, you don't. It's not about the paper. It is not about the paper, JB. It is.
Spoiler alert, it's all about the paper. Stupid bitch.
You've got to have a valid driver's license, but you don't with that paper.
See that? That's funny because if you had a valid driver's license, you wouldn't need the paper. And if only there was part of the vehicle code that said you can't arrest people with privileges reinstated.
You cannot convict someone whose privileges are reinstated.
A place under arrest, turn around, place your hands behind your back. You have the right to remain silent. Anything you say can and will be used against your opponent. Do you understand that? You have the right to an attorney. If you can't afford one, one may be appointed to you. Do you understand that? You have the right to have an attorney present. One may question you. However, for the court person.
The next sentence gives him 30 days on March 24th to complete the four things the council mentioned: pass driver's license exam, pay reinstatement, pay an examination fee. So all we have is a March 24th date where it says you've got 30 days to get these